constitutionality because the law does materially change the status of availability of procedures from the present law. So is it all right with everybody if the state tells me what their argument is to rebut that presumption, and then I hear the plaintiff's argument? Is that all right?
If that's how you would prefer to proceed, of course, Your Honor.
In my head, I think the burden is on, it's unusual because the burden's on the state, at least at this point, to establish a basis that's set forth in the state to rebut that presumption. So if we can do that, that'll help me in the way that I've been trying to think it through since Monday.
Certainly.
Thank you. If you need more time to.
Oh, not at all, Your Honor.
Okay.
I have absolutely no problem with going first. I think I generally agree with the way you framed it. I guess I would just clarify one thing from the state's perspective.
Sure.
We think that, for example, in Gainesville Women Care, when that burden shifted to the state, that was only after the plaintiffs had at least overcome the sort of facial challenge threshold. I mean, of course, we've raised arguments as to that. If Your Honor disagrees with that, that's fine. Again, I have no problem going first, but I just want the record to be clear that I think there's a little bit of disagreement on that point.
Okay, I get what you're saying, and there's a standing issue too. So why don't we talk about assuming that the state gets by. I haven't ruled on that, but what might be helpful for me just to consider the state's argument as to rebutting the presumption, and then we'll go back and I'll hear the plaintiff respond to that, also as to any facial validity issues and standing issues which have been raised by the state.
Sure, so you want me to start with the compelling interest?
Yes, I would like to hear the compelling interest, and I want to go back and have the plaintiff pick up and talk about, the other issues we just discussed.
Okay, so the two compelling interests we've advanced, Your Honor, are in maternal health and in conscious suffering. And I think maybe the place to start is just to clarify something that I think got a little confusing during Dr. Condick's testimony. As I think has been explained to Your Honor several times, there are sort of two ways to calculate gestational age. One is measuring from the time of fertilization, and one is measuring from the last menstrual period. So when Dr. Condick said that fetal pain begins in a range of 12 to 18 months, she was using the fertilization measure. So what she was actually saying, kind of from our perspective, is 14 to 20 months.
So you would add 2 months on it.
Or 2 weeks, excuse me.
I'm sorry, you would add 2 weeks on it to translate her figures.
Roughly 2 weeks. It's not, as I understand it, it's not an exact science, but that's sort of roughly how you do the numbers.
Here's what I had in my notes. I had on her testimony pain 10 to 12 weeks, and then I wrote next to that 12 to 14 if you convert it.
Well, I think when you talk about pain, she's talking about two different things. First, and again, I'm not a scientist, but I'm going to try my best to characterize what I think she said. I think first she's talking about kind of the neural circuitry for response to pain. So you put your hand on a stove, you feel pain, you pull your hand away. That was the earlier time. And then the second time, the 12 to 18, which would be, I guess, 14 to 20, that's where she's talking about the additional sort of neurological development necessary for a conscious awareness of pain. So the first number is just kind of laying the groundwork for the second range. The second range is what the state is asserting as a compelling interest.
Okay, so the state is asserting that at 14 to 20, I'm going to say LMP, last menstrual period, because that's what all the studies seem to be talking about. At 14 to 20 weeks LMP, that the fetus is self-aware and conscious,
I think I would say,
and had a consciousness and awareness of pain?
That's correct, Your Honor.
Are you not going to argue the self-awareness? Because that's what Dr. Condick testified to.
No, we're going to argue that. I mean, I guess it's a little, I don't know if we're saying the same thing when we say self-awareness and sort of consciously aware of pain.
Sure.
I think awareness of the pain is what we're really focused on, but I think it's fair to say that awareness of the self is kind of like a necessary precondition to awareness of pain.
Right.
So I think that's fair, Your Honor.
So yours is maternal health, which is, I assume, risk and mortality in the mental health testimony, and fetal pain is Dr. Condick, basically.
That's correct, Your Honor.
Okay.
And I think what's significant is that the 15 weeks, it has two things in common. It's number one, it's at the early part of the range where Dr. Condick testified that fetal pain is possible, but it's also when the procedure switches to a D&E procedure, which is a different type of procedure, which I understand there's a lot of disputes about the risks associated with that, but even according to the plaintiff's evidence, has a 4 times higher significant complication rate.
Well, that gets to what the evidence is on what the morbidity or mortality rate is and the risk, because I think that's in conflict between your witnesses and the CDC, American ACOG, RCOG, the Academy of Science, Engineering, and Medicine, and some other studies, and then there's Dr. Scop, who has different opinions and criticisms of those studies. And then Dr. Condick didn't testify to, as I understand, to maternal health in any of those what I call medical issues, except for she talked about fetal pain.
I agree with
her area.
Yes, I agree with that, Your Honor. And
okay.
I think Dr. Scop's expert opinion is that the best way to look at these is not to look at sort of the limited data available in the United States, but to look at Scandinavian countries where because they have single-payer healthcare, they have really good data where they can track the same person and see everything that's happening kind of across their medical history.
Would it be fair to state that Dr. Scott didn't think any of the data from the official governmental or what I call mainstream medical associations is accurate?
I
or
think
she questions the accuracy at least?
I think she questions them because I think she believes that all of them suffer from the same data limitations, which are data limitations that exist in, as I understand it, basically all of the healthcare data available in this country because we don't have such a systematic way to track data as we do in Scandinavia. And that's why she believes that the Scandinavian studies are better because when you have a single-payer healthcare system, you sort of have the person's complete medical history in one place, and you can take two populations, people of sort of otherwise similarly situated. You can look at people who had the procedure and who didn't have the procedure, and you can compare different health outcomes. And I think
so. That's not the turnabout study.
Oh, the Turnaway study.
Turnaway.
I think that is specific to mental health, and I think her criticism of that study is a different criticism, as I understand it. And the way I would describe her criticism as a selection bias criticism. So if you're trying to ask a group of people who've gone through something, whatever it is, and you're trying to find out whether they have had a good experience or a bad experience, whether they've had negative outcomes or positive outcomes, and you approach them and you ask them, do you want to talk about this? What I understand Dr. Scott's position to be is that that's what we call selection bias in statistics, that basically people who have had a positive experience are going to be more enthusiastic to participate in the study and to provide information about why their experience was positive. And because the entire study was sort of based on people volunteering and being willing to volunteer, I think Dr. Scott's, again, I'm not a statistician or a scientist, but my understanding of her critique is that that's not a defensible way to conduct a study of that nature. I think she also criticizes the small sample size.
Of course, Dr. Scott is not a statistician either. She's a medical doctor who's never performed the procedure she's opining about.
I would quibble with that a little bit, Your Honor, in that it's the same procedure. Like, basically, as I understand it, the procedure, the D&E procedure involves certain techniques. She does those procedures on miscarriages, so like children that are no longer alive, but she's done the same procedure. So she's never done an abortion in that she's never terminated a healthy pregnancy, but she has done the procedure involved.
There's somewhere in her deposition, which is in evidence, which involves a procedure which was being discussed as of 1981 and coming forward to the present. She indicated she wasn't familiar with how the procedure had changed in the last 40 years. So if you're going to testify as to what the risks are, don't you need to be familiar with the procedures involved and how those have progressed since last 40 years is not necessarily the be-all and end-all, but I think the Privacy Amendment was 1980, so that's...
I don't have that in front of me, Your Honor, but she was trained in medical school on the procedure after the 1980s. So I think what she was saying there is not that she's not familiar with how it's performed now, but that she's not familiar with how it was performed in the 1980s perfectly.
No, she said she was familiar with the procedure in the 80s, and she does not know how it had been proved since then.
Can I pull that up, Your Honor?
I can give you the, if you'll give me a second, I'll give you, I thought I had a page number. Let me see if I can find it. Okay, page 155 of her deposition. And there may be more context that you want to talk about, but my quote that I wrote down is, quote, it was referring to a procedure or a technique from, my memory is 1981. Again, some of this I did at 4:30 this morning, so it's possible there's an error in there. And it says, quote, it's possible there have been improvements in the techniques that make it safer. But my takeaway from that is that she was not, and I wouldn't expect her to be as familiar with that as like, if I were in private practice and I wasn't a tax lawyer, I wouldn't be all that familiar with how to make out a tax return or something. So I kind of got us off on a tangent there a little bit, I think. So I don't recall my point now, but that was a point I noted, is that there seemed to be, from Dr. Scott, there was a unwillingness to rely upon essentially any U.S. data, that being CDC, American Academy of Sciences, medicine, engineering and medicine, ACOG, well, I guess that includes UK too, ARCOG. And at one place, where she said on page 175 of her deposition, she didn't believe that there is any accurate data in the United States concerning abortion and mortality rates. And then on page 91, she says, I think the rates, again, I think that may either be mortality or procedural risk. I'd have to go back and look. But she says, I think the rates are higher, but there may not be a study that documents that.
Yeah,
so how do I deal with that? That's sort of my overall question to you.
Yeah, I mean, I guess I want to start with your initial question, which is looking back at this transcript, here's what I understand. So she was pointing to a study from the 80s comparing the safety of earlier abortions to later abortions to make the general point that later abortions were more dangerous. And she was asked in her deposition, well, isn't it possible that the techniques have improved since 1980? And what she said was that she basically wasn't aware how the techniques had been improved since 1980. But I think based on when she went to medical school and what she's testified about her experience, the best way to understand that is not that she's not aware about how it's done now, but that she's not aware about how it was done in 1980, and thus is not aware how it has improved since 1980 to the present. Well,
page 118, maybe this is a different study. She was referring us to a study analyzing data from the 70s and one from the early 2000s. She said, quote, "I don't have any knowledge of how accurate the mortality data was then versus now." So does she know in her testimony or deposition whether mortality has gotten worse, better, or stayed the same since 1980?
Well, I think the first thing I would say is that her view is that there is a general problem with the way data is collected on abortion in this country. And that is the principal reason that she points to abortion in other countries. And these are not, underdeveloped countries. These are countries with sophisticated healthcare systems. But her point is, because of these sort of inherent limitations in the way we collect this data in this country, overall, that would apply to anybody who's speaking to the risks in this country, because, again, this is her general criticism of the way we collect this data in this country. She thinks the Scandinavian studies are better.
Doesn't she also say, and I understand bias in consideration of opinions, because everyone has an opinion. Every expert who's testified has an opinion, and which doesn't, the fact that they have a particular bias doesn't necessarily mean whichever side they're on, plaintiff or defendant, that disqualifies them as an expert. But Dr. Scott's thought came strongly through to me that there's this data collection issue, but also she gave little or no weight to any of what I call the mainstream organizations and studies. AMA, the article in the AMA Journal, ACOG, American Psychological Association, I think, and I call Academy for short, Academy of Science, Medicine, and I'm giving it a different name every time, but let's just call it the Academy. She expresses that these are pro-choice, that the people involved in the research are pro-choice, and therefore their studies are biased and are not worthy of belief, essentially. That's what I take.
I would disagree that is her sole point. I think that she did, you're right, criticize the bias of some of these organizations, but I think she always coupled that with a substantive criticism of the techniques of the study, and I think she even said, or she would say, that in her view there's a methodological problem that's not being acknowledged fairly, and that one of the reasons the bias is relevant is it sort of explains why, in her view, a problematic methodology is not being corrected.
Didn't she criticize the Academy study on mortality and acknowledge that she didn't really even know how that study was set up? She said she'd have to dig into it to find out what they considered. I'm loosely paraphrasing. I can get you a quote if you need it.
If you show me the page.
Okay, let's see if I can find it. Let's see first if I even wrote this down. So if I didn't, I won't be able to find it that quickly. Oh, she did admit on page 155 of her deposition that it's possible there have been improvements in techniques that make it safer, which strikes me as not that much of an admission, because even the questions from the state are assuming that medical techniques have gotten better in the last 40, 50 years. I really don't think there's any dispute about that. Methods used for abortions have changed. There's different ways of dilating the cervix now than they did before, all of which you would expect to have lower side effects and lower mortality as a result.
I mean, I think the state's position, though, is more about the relative risk than the overall risk.
Right.
Basically that the earlier procedures are significantly safer as a relative matter as compared to the later procedures.
Mm-hmm. Let me see if I can. I'm going to have to go through and find it. One of her other criticisms of the Academy report on D&E related hemorrhage is that the study is biased because it only looks at the good doctors and not the bad doctors. So it seems that she thinks the more experienced you are, the less valid data on your practices should be considered. That we should look at the lowest common denominator in which to set policy, that is, the bad doctors.
I don't think that's what she's saying.
I don't think that's what she intended, but that's sort of what she said.
No, I think what she's saying is that a study that only looks at the sort of top tier and it doesn't look at the entire range is not an accurate reflection.
Well, isn't that like saying there are dentists who are killing people in the office constantly when they're filling cavities? And we can stop that by not allowing any dentist to fill cavities. We can solve that problem instead of saying, why don't we get rid of the dentists who are filling cavities wrong and killing people? That, to me, that's where I see an issue with her analysis.
I mean, I agree with the second half of what you said. I disagree that that's what Dr. Scott said, or so I disagree with the premise. I think what she is saying is that when you are trying to figure out how risky something is, you look at a representative population. So you would look at doctors, sort of 1% through 100%. You wouldn't just look at the top 50% because that wouldn't accurately capture the risk.
I do have a question. I'll get off that topic on something else. I do have a question because I guess TW talked, the first case, TW, says that there must be a compelling interest to prove that the law is constitutional. There must be a compelling interest through the least restrictive means. And they quote TW, a comment in there indicating that maternal health is not a compelling interest until you're 24 weeks or later.
I thought they said second trimester.
It could be.
Second trimester is early.
I will defer to whatever they say. But here's my question. When the Privacy Amendment was passed, let's say 1980, I don't want to tie too much to 73, 74. So when the Privacy Amendment was passed, 1980, and there was a certain state of risk in the first 24 weeks, which I think is still the law today, and I think it's based on viability, or that's the way Florida, I think, come up with a 24-week figure. You could do abortions from 1 to 24 weeks, and there was a certain level of risk involved in the procedures in 1980, both first and second trimester, and I believe there's evidence to show that in general, all the procedures have gotten better and safer, but I have found no evidence, unless you can point it out to me, that any of the risk or mortality has gotten worse since that time. So if I'm correct in that premise, what is the compelling interest through the least restrictive means to correct a situation where the maternal health issues have not gotten worse? In fact, they more likely have gotten better. So it would be like, I'll try a different analogy. Football season's coming up. The reason there's all these rules in college and NFL about spearing and not roughing the quarterback and all that is because there was a real problem with roughing the quarterback, and just calling penalties on it wasn't stopping people from roughing the quarterback. In fact, it was getting worse. So they passed these restrictions on you can't spear, you can't do other things. And it seems to me compelling interest should take a situation that has gotten worse and gets better. Or I think I understand your argument is if there's any risk or any mortality, then it's a compelling interest to lessen that?
I don't think that's exactly my argument, Your Honor, but I think there were a few questions in what you just said. I want to take them piece by piece if I can.
Sure.
I'll start with, I think your factual question is, has it gotten more risky? I don't think there's evidence of that, but I do think there is probably more evidence on the safety available than there was in 1972. And a very good example of that is the Scandinavian study, which is a truly sort of comparison population study and looks at
really Scandinavia is comparable to the U.S.
In terms of the healthcare. I wouldn't say it's
healthcare, poverty levels, educational levels, diversity of population. Don't you see obvious differences?
I mean, I see a lot of differences. I'm not sure why those differences would affect sort of healthcare related.
Would they affect, for example, in the U.S., in certain sections of the U.S., there's a higher infant mortality rate in general, not related to abortion, but in general. And it's generally tracked to economic circumstances and education circumstances, in some cases fear of the health system, etc. Are those figures exactly the same in Scandinavia as they are in America?
Of course not, Your Honor. But I think there's something really important that I think I want to clarify about a comparison study. So when you're doing a comparison study, a properly controlled study, which is the gold standard in science.
You factor out those differences.
Well, you don't factor them out, but the purpose of the Scandinavian study is not just, here's the overall complication rate or the overall death rate. It's saying, here's a control population, and then here's an otherwise similarly situated population that has had this procedure, and then it's comparing them. So what it's meant to capture, what a study like that is meant to capture is the effect of having the procedure specifically. And so I think that would control for a lot of the differences that Your Honor is describing, but I do understand the point you're making.
Yeah, the issue, though, is I understand that if you take any medical procedure and you limit the use of that medical procedure, you will have fewer side effects and fewer deaths as a result of that medical procedure, regardless of what it is. By the way, I did survive my crown Tuesday, so I know that's not that bad. But no one told me which dental procedure has a higher mortality rate than abortion, and I'm not sure I wanted to know. But I understand the concept that with any medical procedure, there are risks. Colonoscopy, there are obvious risks there. That, and at least according to the Academy and I think CDC and others, it's a higher risk of death than abortion, legal abortion, volunteer legal abortion through the 24-week period, I'll call first and second trimester. And if you say, instead of saying everyone from 50 and older should get it, you say you can't give that until you're 65. Well, you will have fewer complication rates as a result of that because that procedure is limited. So it can't be a compelling state interest to cure complication rates, can it, by just limiting the procedure if the procedures are being done correctly? Now, I'll give you an example of where it could be, I think, a constitutional limitation. Require the doctors performing the abortions to either have privileges at a local hospital or there be an arrangement that there's a doctor who has privileges, excuse me, will be on call at that local hospital to receive patients with problems. That might already be in Florida law or a regulation. That technically is a restriction, but it seems to me it serves a compelling interest that we know there's going to be a certain number of complications, and a doctor can't come into town, do abortions, leave town, and provide no means of aftercare should a patient need aftercare. That, I think, would be an example of a constitutional restriction. Abortions after viability, I think, based upon all the case law I've seen, would be an example of a constitutional, in Florida, restriction on abortion. The Supreme Court says there's a right of privacy for abortions, but I think it's always drawn the line at viability from my reading. So that's a constitutional restriction on that. And the rub is, where do you draw the line? And it's not as easy as it might look for someone who's outside this courtroom as it is those of us who are inside this courtroom. So how do I get past the argument that I'm going to hear from the plaintiff that all they want to do is reduce the number of abortions? Yeah, that will cut down on mortality. Or if you cut it from 24 weeks to 15, yes, that would, because as we know from the testimony, most of the procedures now up to 15, not all, but I would say probably the vast majority, are based on medication, not an actual surgical procedure. So there is a lower risk early than there is late. But how do I rationalize that with the fact that all medical procedures have complications?
So I think, respectfully, there is a false premise in the way you framed that entire issue.
I would be glad to hear it.
I think the false premise in what you've laid out is the idea that if you cut things off at 15 weeks, every single person who was having a post-15-week abortion before is simply not going to have the procedure.
Oh, I agree with you. Some will, and I think there's some testimony to say in some other states.
Or they can have them earlier, which is safer.
Yeah, some will not get them. Some will get them before the 15 weeks. I don't dispute that, but some won't know that if there's a amniocentesis that's done at 15 or 16 weeks, and it turns out there's a horrible birth defect that this child will not survive for 6 weeks or 6 months or whatever. If that's not discovered until after 15 weeks, under HB, is it 5?
Yes,
HB 5, there's no remedy there, at least in the state of Florida. You would have to travel to a different locale. If someone is the victim of, there's an acronym that's used for this in there, partner violence. I don't recall the acronym, but your partner that you live with, the person you live with, engaged in violence. And part of domestic violence, we all know, is excessive control of the other person. Violence is, I'm not a sociologist, but I've handled thousands of domestic violence cases. Violence is a means of control, among other things, in a domestic violence situation. Limiting the person who's the victim of violence from leaving the house is a means of control, which is often the case. There's testimony that here in the case. There are studies of that. So with a 15-week cutoff, there's going to be a certain number of people who are victims of domestic violence who just can't get out of the house until week 16 or 17. They will have no option, at least in Florida. They will some other place. I get that, but in Florida they won't. If someone is raped, and we see this all the time here in our criminal courts. Women are raped and they're so traumatized they won't testify at trial. They can't bring themselves to do it. We recently had a criminal trial where a woman was raped and the woman was so traumatized she didn't testify, and the conviction was reversed and came back down to be tried, and like a couple of years later she was able to come in and go through that process. So I can't give you numbers, I can't tell you it's high, low, or medium, but we know that there are women who are raped who take a long time to process what happened to them. And it might be in week 16 or 17. So we have that. So I do agree with you that there will be some people in a 15-week ban who will get their abortions earlier. They won't have to travel out of state. And they will get them here, likely with few, if any, complications. But I don't think we can say that that's everyone. So that's the issue I'm confronting on that point. I don't think I disagree with you on your factual statement there at all.
Pleased to hear that.
Well, let's say I don't completely disagree with you. But there will be a number of women who will make an extra effort to get within the 15 weeks. Now, it's harder in Florida than some other states because not only do you have to get in 15 weeks, you have to come twice within 15 weeks under Florida law. But that's not in front of me.
That, understood.
So, the other states, I don't know, was it Texas where they've done some studies on people coming in earlier? Was that the 6-week cutoff in Texas?
That sounds correct.
I don't know if those states require you to come in twice before the cutoff.
I strongly suspect that they do. Waiting period laws are incredibly prevalent, but I don't have that in front of me.
It may, but it just makes it doesn't make it impossible, but it makes it harder to come in twice. Not from a standpoint, oh, I'm going to change my mind. I'm talking about from the standpoint, I have a job, I need to take off twice. I have a guy who's beating me up every other night, and there's only so many times during the day where he gets out and goes, and I can escape and get out there. So I'm not here to litigate that case. That case has been done. It's not in front of me. But you have to take into context the existing law of Florida, which that case now is, and what happens when you push it back from 24 to 15. There's going to be a certain group of people that it will be harder for them because of the waiting period to get in early. But I do not doubt your suggestion that a portion of those that are getting after 15 weeks now will get them before 15 weeks in the future.
And the plaintiffs concede that that is a procedure. If they go earlier, it's a procedure with a lower complication rate.
Yes, it is.
I guess one reaction I would give to what you just said, Your Honor, is, and I don't want to put words in your mouth, but I just want to tell you kind of what I'm hearing. Mm-hmm. What I am hearing is that you have concerns that there may be particular applications of this law to particular people's circumstances that you think might be unconstitutional.
And you think that's not facial?
Correct. That is exactly my position. That's exactly what the First District said in Gainesville Women Care. In fact,
they were reversed.
No, the second time.
The second time?
And that is...
Oh, in the second time, they just said there was a disputed issue of fact.
But they said a lot about the facial challenge standard, Your Honor, and they said that as their interpretation of the first Gainesville Women Care decision in the Florida Supreme Court, and the First District's decision characterizing the holding of the Florida Supreme Court, I think, is binding in this proceeding. And they were very clear that, they actually articulated many of the hypotheticals you've just articulated and said those sorts of hypotheticals are only accounted for. And I'm not disagreeing with you that those are very sympathetic hypotheticals. I'm not pushing back on that at all, Your Honor. I'm just saying that I think the First District was very clear in the second Gainesville Women Care case, which is binding, that those are not relevant to a facial challenge.
Well, haven't you argued somewhere that dicta's not binding on me?
Well, I don't think that was dicta in that case.
I read all those cases last week. And what I do know is the First District, the first case, which roundly criticized, wasn't me, roundly criticized the then Chief Judge who entered that order, and reversed him, was then itself equally round. I'm not a big fan of criticizing other lawyers or judges, etc. I don't think it doesn't feel good when it happens to you. But they roundly criticized the First District. I'm not sure that either side produced anything other than heat in the round criticism, but they disagreed strongly. And I still think the main object of the First District in the second opinion was there's a disputed issue of fact. And now, I understand what you're saying, and I will read that again sometime today before I rule. But again, I'll read it again in light of what you said.
My read of that decision is that they had sort of two conclusions. One, there were disputed access to compelling interest, and two, the trial court applied the wrong standard. They said both things as a basis for reversal, and they instructed the court on remand.
Well, they said Judge Lewis shouldn't have used summary judgment, and then the case came back down and it was decided on summary judgment. What changed?
Well, we had discovery, Your Honor, and plaintiffs withdrew all their fact witnesses. I was involved in the case. I actually argued the DCA reversal. So,
well, you obviously did a good job.
Your Honor.
Okay. All right. I was not involved in that case. What I know is what I've read in the case reports.
I guess what I would say, just respectfully, is regardless of whether Your Honor believes that this first DCA's second time around with that case was faithful to what the Florida Supreme Court said, I think an intermediate appellate court's sort of post-decision interpretation of the Florida Supreme Court is binding.
Is it binding if it differs from what the Florida Supreme Court has held? So what if the First District says something about the right of privacy that varies from one of these Supreme Court decisions? How do you deal with that?
I mean, I think it would be binding. There might be outer limits where I just haven't thought about that, and I don't have an official position on that, but I just don't think that's what's going on here.
Neither do I, really. But I will think about that, and I will read that opinion again. Sorry, I've interrupted you with a series of Socratic dialogue.
That's quite all right, Your Honor. Well, where do you want to go from here, Your Honor? I have a whole presentation prepared, but I can see you're focused on certain things.
I think here's where I think your argument is that the compelling circumstances is the testimony you provided on maternal health, and maternal health is subdivided into risk and mortality and mental health.
Yeah, and I would think of all of them generally as sort of fatal and non-fatal complications if you're willing to view mental health outcomes as
in fetal pain, I got to be honest with you, I have real questions about Dr. Condick's testimony that there's fetal pain when there's almost no brain at that stage.
Well, I think, she talked about the question of whether the thalamus is enough for a conscious experience of pain, and I think she pointed to some studies that actually demonstrate that. One of them involved two populations of people, one who were more pain sensitive and one who were less pain sensitive. And what they did is they took those sort of two groups of human adults, and they gave them painful stimuli. They poked them or something. And all the participants, the pain sensitive ones and the non-pain sensitive ones, said that hurt. They reported experiencing pain. But they monitored the brain activity, and the pain sensitive people had activity in sort of the part of the brain that plaintiffs say needs to be developed for conscious experience of pain. But the non-pain sensitive people only had brain activity in the thalamus. They didn't have brain activity in the portion of the brain that plaintiffs say is an essential component.
So the people that said there's no pain only registered in the thalamus?
No, everyone reported pain. It's just
everyone reported pain.
It's just that some of them were pre-screened as pain sensitive, and some of them were pre-screened as not pain sensitive. So the way I would think about it is that while there may be certain emotional reactions to pain that you need that full development for, the just threshold question of can you consciously feel pain, like the category of people who are not self-reported as pain sensitive, they reported pain, and that only involved thalamus activity.
I may have this wrong, I think the plaintiff in one of its memos cited some cases from some other states that critiqued either Dr. Condick or Dr. Scott I think Dr. Condick on the pain issue. Does that ring a bell for you at all?
I know they cited those cases. I don't think that's part of the record properly in this case.
Well, it's a case, isn't it? It's a case on, if you ask an expert, have your opinion ever been rejected by another court? That's not a relevant consideration. If another court has rejected it?
I mean, they could put that in the record, but I think just the fact that the case alone is not. I mean, one thing I would say is if you actually look at Dobbs itself, Dr. Condick offered an expert declaration in that case. It was rejected, but if you read the concurrence of Judge Ho in the Fifth Circuit critiquing the district court's approach and not allowing that evidence, we didn't provide that to Your Honor, but I am aware of that. Mm-hmm. And so again, she was the offered expert in the case that the U.S. Supreme Court just decided, and at least one Fifth Circuit judge was heavily critical of the district court for not allowing that evidence.
I don't recall. It may be in there because that Dobbs case is a long decision. I read a lot of it over the weekend. If they discussed the pain issue or not,
I don't think they did because they jettisoned.
They just threw they threw it out on the implied, as I understand, implied right of privacy. And this issue of that abortion wasn't allowed in 1776 or something of that nature.
I would characterize it slightly differently, but...
Well, what did they say? I mean, I thought they went back to when the Constitution was written and looked at what medical procedures were common at that time.
Yeah, I think that was certainly part of their analysis, that it wasn't sort of a clearly established right from the beginning.
Okay. So what do you think on the fetal pain situation? The comment in TW I think the plaintiff has made is that issues like that are not for the court to consider before viability, but only after viability. If I can maybe find you the...
I know exactly what you're referring to. I think what they say is that the state's interest in potential life becomes compelling only upon viability.
Right. I think, let's see, TW, I think it was on somewhere around Headnote 6 in that area.
But, I mean, the way I would think about at least the current state of Florida's right to privacy case law is it's a strict scrutiny standard. Mm-hmm. So it's not saying you can't do these things. It's saying the state has to satisfy this standard. And if you look at sort of the right to privacy case law overall, not just in the abortion context, it's an area of law where the state is frequently successful. It is not the sort of equal protection, strict in theory, fatal in fact. It is a standard that the state has satisfied. And so at most, now we've raised arguments about whether that's dicta and all those things, but I'll put that to the side. At most, I would read in Re TW to say that the specific interest, an interest in protecting the life of sort of a child in utero, fetus, whatever you want to call it, does not become compelling until viability. But an interest in preventing conscious suffering, I think, is just a different interest that the court hasn't opined on.
Okay, well, here's a section in TW. What year was this? 1989. Okay, TW, I'm trying to find you. This is Headnote 6, page number 1193. Give you a general reference, but it says, quote, under our Florida Constitution, the state's interest, I think this is dealing with the fetus, not the mother. I think that's the context of the quote. The state's interest becomes compelling upon viability as defined below, which they, I think, define as 24 weeks. So if that's still the law now, all I can look at is what is now. Am I permitted to consider this fetal pain issue based upon that statement in TW?
I mean, we think so only because we think that the court was not specifically addressing this interest, but we certainly have a dual interest here, Your Honor, and the other interest is just creating our record for appeal. So.
I understand. I had another question, and then it just escaped my mind. It'll come to me sooner or later.
Well, I don't want to. Yeah. I don't want to take the wind out of your sails, Your Honor. I mean, at this point, I would probably move on to standing or irreparable harm. But if you want to keep talking about the merits, I've got it.
All right. I think I understand where the state's position is on compelling circumstances, maternal health, fetal pain, and I think it would be appropriate now. If you would like to make the argument on standing and the other issue, then the state could come and respond to that. I'm sorry. The plaintiff could come and respond to that.
Is that you want me to talk about?
Yeah, why don't we do that? That'd be helpful.
I'll start with standing. As I think everyone agrees, I'll let the plaintiff say what they agree with, but at least our position is that no plaintiff in this case is asserting a personal right to privacy, so this is a third-party standing doctrine case. I think Your Honor is absolutely right what you said at our first hearing, which is that there is no sort of categorical bar to people in the plaintiff's position asserting the privacy rights of their patients, at least under existing law. We recognize that. That has been recognized in many cases. But our position is, regardless of whether people in a certain situation have been allowed to do that in the past, in every specific case, the plaintiff has to satisfy the three elements in Altera. Now, the question is not can they satisfy it, the question is did they offer the evidence in this case? And in our view, two of the three elements in this case, on this record, and on this complaint, they neither made the necessary allegations nor offered the necessary evidence. And let me talk about those. So there's three elements. There's injury in fact, close relationship, and the inability of the person who possesses the right to sort of assert their own rights. We agree, at least under existing law, that the close relationship requirement is satisfied because you have a doctor and a patient. So what we're focused on is injury in fact and the ability of women to assert their own rights. And what's notable is that plaintiffs don't even articulate this test in their complaint. They just sort of ignore it. They just sort of assume that because they're a doctor going on behalf of their patients, that they just have third-party standing. And we just don't think that's consistent with the Florida Supreme Court's decision in Altera. So I want to start with injury in fact.
Okay.
The whole point of injury in fact is not does the third party have injury in fact, but does the plaintiff have injury in fact. And if you read their filings, the entire focus of their briefing is harm to Floridians, harm to our patients. But for the injury in fact requirement, they have to show that they're injured. Now, I have little doubt that if plaintiffs put together the right record, they may very well be able to show loss of, financial injury. If you look at Planned Parenthood's website, second trimester abortions are apparently more expensive. I don't know if they make more money off of them, but they certainly charge more for them.
They charge more. They might be more. There might be
more cost.
More cost too.
But they certainly could have offered that evidence, but they didn't. And so the question is, on the evidence before the court, have they shown injury in fact to themselves? So there's sort of, I think, two other injuries in fact they assert, although some of those, there's irreparable harm and there's injury in fact. I think they're an overlapping inquiry. The first and principal one they assert are the penalties, discipline, criminal penalties, things like that. The state's position, however, is that the clear testimony and representations have been that when this law goes into effect, they're going to stop providing services. They're not going to go provide the services and face the criminal penalties. So they can't say that the criminal penalties inflicted injury in fact. Now, I want to be very clear what the state is not saying. The state is not saying that a person has to violate the law, be punished, and have standing.
Right.
I'm saying something very different, which is if your plan is to cease the conduct to avoid the criminal penalty, then you have to show that that cessation of conduct inflicts an injury in fact, which goes back to, for example, financial injury. So we're not saying that a plaintiff in their position could not meet this, and that's why I think there are several cases finding that they've met it. Our point here is that they just simply chose not to offer that evidence, and this is an essential element of third-party standing. Let me just figure out where I am in my outline here, Your Honor, when I have a minute.
Okay.
The other prong, I think the other thing I was going to talk about more goes to irreparable harm, so I'll skip to the other prong. The other prong is the ability of women to assert their own rights, whether a person who was in the circumstances Your Honor described could go file an as-applied challenge. Now, we have cited several cases where women in Florida have brought such a challenge. But again, I think the essential point is not whether I or you or the plaintiffs believe that women can do that. The question is, did the plaintiffs make this allegation, and did they offer proof of it? And if you scour their entire complaint, there is not a single allegation that women cannot assert their own rights in court. And we just think that is fatal under the third-party standing test in Altera. Now, in the reply brief, the plaintiffs essentially argue it's so obvious that women cannot do this that we don't even need to offer proof of it. I think that's around pages 23 to 24 of their reply brief, Your Honor. But in doing so, they essentially assert a bunch of facts that they've neither alleged nor proved, and they just kind of throw them out there in their reply brief. But as Your Honor knows, that's not how a factual record works. You can't just sort of say things in your reply brief and expect them to be part of your complaint and a part of the record. I think there are some notable things about the contentions they make in their reply brief. For example, they rely significantly on the mootness doctrine as a reason that somebody cannot bring a case on their own behalf, that the case might become moot before they can litigate the case. But of course, there's a very well-known exception that applies in this circumstance. It's the capable of repetition yet evading review exception. It's the exception that allowed Roe, in that case, to bring her case. Roe's not her real name, as I'm sure Your Honor knows. She's anonymized. In Re TW is another example that obviously that's not the person's name was not TW. She was anonymized. And so we just don't think on this record that they can satisfy this essential element to their standing. That takes me to irreparable harm, unless Your Honor has questions about that.
No, I'm following you.
Okay. On irreparable harm, we see the irreparable harm allegations as three different things, and I'm going to do them slightly out of order because I think we can just knock one off very easily.
Okay.
Criminal penalties, as a matter of clearly established Florida precedent, are not irreparable harm because a person can raise the constitutional claim as a defense in the criminal proceeding. We cited a lot of case law on that. I did not understand the plaintiffs to push back significantly in their reply on that. I'm sure counsel will let me know if she disagrees, and I'll welcome the opportunity to talk about that more, but I want to put that one to the side because I think that's the easy one. The other two theories of irreparable harm are two. One is loss of constitutional rights. And I think we agree that there is significant case law that says that the loss of constitutional rights is irreparable harm. And in fact, the Florida Supreme Court said that in Gainesville Woman Care. But there is a wrinkle to that, as we're aware, was not addressed in the Florida Supreme Court. And we think it's an important wrinkle. And it's the interaction between the third-party standing doctrine and irreparable harm. In our view, just like the plaintiffs have to show injury in fact, the plaintiffs have to show that they are irreparably harmed, not that someone else is irreparably harmed. And we think this is particularly important in light of the way Judge Tannenbaum described the constitutional writ of injunction in Berg.
Which we all agreed is not applicable to this case.
I don't agree. I don't agree with that. I think that
I thought we did at one of our hearings.
No. So let me explain that. I think that's really important, Your Honor. There are several things in Berg. There are several things that the court said. The court made some general statements about the constitutional writ of injunction. Those statements about the nature of the constitutional writ of injunction absolutely apply in this case. The thing that does not apply is his statement about the status quo, because everybody agrees in this case that the relevant status quo was before HB 5 was enacted. And so an injunction would preserve the status quo. But Judge Tannenbaum said a lot of other things about the writ of injunction, and I'm going to get to some of those when I talk about the scope of relief, that I think are highly relevant to this case. And one of them is that the purpose of a temporary injunction is to preserve the status quo between the parties and prevent irreparable harm to the parties. So the parties who are here today asking you for relief have to show that they will suffer irreparable harm and that the status quo needs to be preserved for that purpose. And so pointing to sort of the general irreparable harm of Floridians does not satisfy that test. Now, I think that takes us to their other theory of irreparable harm, which they call interference with the doctor-patient relationship. And I think the important point here is that this is not some case where some private actor is interfering with the doctor-patient relationship. The state is setting medical standards. Every single medical standard that the state sets affects the type of care that doctors can provide. Doctors comply with the law. If the state says do this procedure differently, if the state says report this information, if the state says wait 24 hours, all of those things are going to affect the way a doctor provides care. But it cannot be the case that every medical regulation that was ever enacted irreparably harms doctors because it interferes with the doctor-patient relationship. Because a precondition to practicing medicine in this state is complying with state law. And doctors have no right to have a doctor-patient relationship that is not in accord with state regulations. So we don't think that's a viable theory of irreparable harm either. And as we understand it, those are the only three theories that advanced. I have, if Your Honor has questions about that.
Now you want to go to the facial challenge?
Yeah, I talked about that a little bit already, but I'm happy to say more about it.
And once you finish with that, then I'd like to turn it over to the plaintiff. We might take a short break, but then turn it over to the plaintiff to let them start.
That would be fine, Your Honor. On the facial challenge, I mean, I think I've already explained what the standard is, and I can say it again. It has to be all women in all circumstances.
Mm-hmm.
I think we've described, and the plaintiffs have agreed, that the relative percentage of abortions this applies to is low. I think the more important point, because plaintiffs' objection to that is, well, no, you have to look at the situations the law applies to and then see if it's unconstitutional in all of those applications. And I think that's where it takes us back to the conversation you and I had about how you agree that at least some women will simply schedule their abortions earlier, resulting in a procedure with a lower complication rate. And so we think that at least the law's application to people who are going to get an earlier procedure with a lower complication rate, that the law does not violate the rights of all women in all circumstances because of that category of people, regardless of how you feel about kind of all the other issues we've been talking about. So I think I can talk more about it, but I think that's the state's basic position.
Okay, so can we give the court reporter a break?
Yeah, sorry, am I talking too fast?
No, you're fine. She's been working for over an hour straight. So let's take 15 minutes off and come back at 10 after, and then we'll start with the plaintiff.
Thank you, Your Honor.
Thank you so much. And I'm going to try to grab that Gainesville opinion in that break and read it real quick. I read the Gainesville case again. Thank you for referencing that. So, a plaintiff? Oops, sorry about that. So you can start wherever you wish to start. Standing and facial challenge might not be a bad place to start.
I'm happy to start on standing and facial challenge if that's what Your Honor would prefer.
So long as we do address that at some point, I'm fine with
okay.
How you want to
I
deal
certainly
with it.
am planning to address that. What I was going to do was sort of go through the issues in the order with which Your Honor discussed them with opposing counsel.
Okay.
And certainly we'll touch on the facial relief and third-party standing as part of that.
Mm-hmm.
There are 2 points that I just wanted to make at the very top that I think are important to keep in mind when evaluating the question overall. The first one is that the state of Florida already has a ban on abortions after viability. That law is not being challenged in this case. And as a result, the only question here and the only effect that HB5 has is as to pre-viability abortions. And under the Florida Supreme Court precedents in Re TW, neither the interest in maternal health nor an interest in fetal life can support a ban on abortions before viability. As some of Your Honor's comments in the colloquy with opposing counsel acknowledged, of course, the interest in maternal health is compelling in the second trimester, and that can support certain regulations to advance the quality of care, to make sure that the provision of abortion care within the state is safe. But the TW case does make clear that there's a distinction between regulating in the interest of maternal health versus passing a ban that would cut off access and take the decision to have a pre-viability abortion out of the hands of individual women entirely. That's what HB5 does. And under the precedents there simply isn't, the state cannot satisfy strict scrutiny with a ban of that nature. I think the second point that I just want to emphasize up top, and that again has already been alluded to, including in sort of the order of the arguments this morning, is that under strict scrutiny, the state bears the burden of proof. And so that means the state has a very heavy burden to offer through evidence that it has a compelling interest at stake in this issue, and that HB5 actually advances that interest and does so through the least restrictive means. And none of the evidence that the state has put forward with respect to either of its asserted interests is sufficient to withstand that very heavy burden. So I'd like to take each of the asserted interests in turn, and I'll start with maternal health. So first, I think it's important to remember, as Dr. Tien testified, that there is ample evidence that abortion is extremely safe at all gestational ages, including after 15 weeks LMP. And critically, abortion is far safer than the alternative, which is to continue pregnancy and carry to childbirth. The state has made a lot and put a lot of emphasis on the notion that abortion is safer earlier in pregnancy and that the risks do increase with gestational age, and that is true, as Dr. Tien testified. But those small increases in risk with the abortion procedure pale in comparison to the huge disparities in safety when compared to the maternal mortality risks. There was some discussion about what medical science and medical sort of safety and statistics have changed since 1980. I think one of the most critical things is that in recent years, maternal mortality rates have gotten worse. The maternal mortality crisis in this country is shocking, and it is rising.
That's the non-abortion.
Non-abortion related
Right.
maternal mortality, correct. The risks of death associated with childbirth are 12 to 14 times higher than the risks of death associated with abortion. So when considering the state's arguments about maternal health and safety, I think it is important to keep in mind that what the state is asking is that for women denied an abortion under HB5, the state is in effect mandating the medically riskier course for them. And in those circumstances, HB5 cannot advance an interest in maternal health. I think the second piece that's important on the state's asserted interest in maternal health is there's been emphasis on encouraging earlier abortions. But also, as Dr. Tien testified, there are many women who are not going to be able to obtain abortions earlier. The reasons that women obtain abortions after 15 weeks are varied, but in general, there are circumstances that are already very complicated. These are women who are not able to obtain abortions earlier because of very complicated life circumstances. They may not know they're pregnant. They may be facing intimate partner violence or poverty-related obstacles that impeded their access to earlier abortion, or they may be experiencing maternal and fetal health conditions that either do not arise or that significantly worsen after 15 weeks. None of those circumstances are going to magically vanish just because HB5 is in effect. And again, so for those women, there will not be a possibility for them to get abortions earlier, and HB5 will act to deny them access to care within Florida.
Let me ask you this question, and this leads me into one of the comments that the defense lawyer made on facial challenge issue, and I know you're going to deal with that exclusively. But I think your argument, and tell me if I'm wrong, is that in Florida, the status quo today is that all women have a right to an abortion up to week 24 during non-viable abortion up to week 24, no matter the reason. It's their choice. And HB5 is a substantial restriction on that by taking 9 weeks off that period and adding certain restrictions within the post 15-week period that aren't there now. And is it your argument that therefore the significant restriction of HB5 affects all women's fundamental rights of privacy as now exist in Florida?
So, Your Honor, I think this speaks directly to the facial challenge, so I'm happy to sort of address it on those terms. I think what's critical to keep in mind is that when considering facial relief, the question under binding Florida Supreme Court precedents is whether there is any set of circumstances in which the law can be constitutionally applied. The state has referred to abortions before 15 weeks, but HB5 does not apply to those abortions. The state concedes in their brief that as to women accessing abortion before 15 weeks, there is simply no effect. So the relevant body of abortions that are going to be affected by this law are only those taking place after 15 weeks. And those are the only abortions that need to be considered in determining the facial challenge. And that's completely consistent with the first DCA's decision, the second decision in Gainesville on the second summary judgment decision, when it referred to whether the law violates the rights of all women in all circumstances. I don't think the state even reads that strictly literally. It's not the case that there needs to be a showing that all women, whether they are seeking abortions or not, or are pregnant or not, have their rights violated by the enactment of the law. The question is whether those to whom the law applies, whether all of their rights are violated.
But all women in Florida who have the ability to bear a child, all women in Florida have the right, as of today, to choose to have an abortion if they get pregnant within the first 24 weeks of pregnancy.
Correct, up until
Period.
viability, yes.
HB5 restricts that for all women as far as their choice to do it within a 24-week period.
Yes.
Okay. And I understand your other point, too.
Right, and so I think, with respect to those who are able to seek it earlier, those just aren't circumstances in which the law is being applied, and so the existence of those circumstances can't be taken as situations in which the law is constitutional because it doesn't apply at all. And the other distinction that I wanted to make with the Gainesville case is that in that case, the mandatory delay law applied to all abortions in the state. And so the court, in using the language that it did, was referring to the rights of all women seeking abortions because that was the scope of abortions that were going to be affected by that law. Not so here, where the only abortions affected by HB5 are those taking place after 15 weeks, and those are the ones that are relevant to the facial relief test, because those are the only circumstances in which the state would need to prove that it can constitutionally apply HB5 after that point. And I think, one thing that's that I would also note is that the consequences of the state's argument otherwise, that the existence of abortions before 15 weeks can somehow save this law from facial invalidity, has extraordinarily broad implications. According to the state, if that were the case, then it would mean that a ban at 12 weeks or 8 weeks or even 5 weeks would also be immune from facial challenge, so long as there are some women, no matter how few, who can still access legal abortion within Florida. And under that theory, it seems that there's no abortion restriction that would be susceptible to a facial challenge unless it prevented every single abortion in the state of Florida. There's no support for that in the case law, and it doesn't make sense as a logical matter either. It would make a mockery out of the notion of fundamental rights for the state to be able to restrict abortion rights so broadly and to only have inadequate piecemeal as-applied relief be the only possible remedy when every circumstance in which the state would be applying the law would be a violation of the fundamental rights under the Florida Constitution.
Okay. I think that's your position on facial challenge.
That's correct.
I interrupted you. Let's go back to the point I interrupted you then.
Sure, okay. Absolutely. So again, I was talking about abortion safety, and again, I think the testimony of Dr. Tien, I think, makes clear that the comparative safety between abortion and childbirth is really the relevant set of circumstances here. Where the state is mandating that women undertake the medically riskier course, it cannot be said that cutting off access at 15 weeks advances an interest in maternal health. And what the state offers in response to Dr. Tien's testimony is the testimony of Dr. Scott. And under the state's very heavy burden, Dr. Scott's testimony simply cannot carry the weight that the strict scrutiny test placed on it. As Your Honor sort of alluded to, Dr. Scott in her testimony admitted that her own opinions about the safety of abortion are not supported by leading medical organizations. She does not trust modern abortion statistics from any U.S. organization or government authority, and instead asks Your Honor to look to abortion statistics in other countries. But again, this is an issue on which the state bears the burden, and there's no evidence to suggest that those statistics would be comparable within the U.S. Within the U.S., what we do have is a great deal of research and a great deal of analysis of abortion safety, as Dr. Tien explained, all of which points in a direction directly opposite to Dr. Scott's opinions. What Dr. Scott is asking this court to accept in place of this host of information from organizations like ACOG and the CDC and the AMA is just her own speculation and innuendo that all of these organizations are infected with such extreme pro-abortion bias that nothing they say or publish on the question can be trusted. I also want to address specifically Dr. Scott's claims about safety rates for abortion later in pregnancy. And I want to just remind that Dr. Scott has never herself performed or recommended an abortion. By contrast, Dr. Tien has the most advanced medical training of any expert in this case as both an OBGYN and a specialist in maternal fetal medicine, which involves treating complex pregnancies. She's treated thousands of patients facing complex pregnancy issues, and she's the only expert in this case with experience both providing abortion care and caring for women who carry their pregnancies to term. Dr. Scott's testimony made a lot of allegations about the potential for second trimester abortion techniques to damage reproductive anatomy or have consequences for later fertility. But as her declaration made clear, these studies and science that she's relying on there are wildly out of date. And as Dr. Tien's testimony made clear, they are disconnected from modern practices in the provision of second trimester abortion care. Dr. Scott admitted on her cross-examination that she's not aware of any current evidence, any current data that suggests that second trimester abortions are unsafe to the degree that she says. And again, this sort of speculation just simply is legally insufficient to carry the state's heavy burden of proof to show that HB5, in cutting off abortion access at 15 weeks, is advancing an interest in maternal health. I also want to address briefly Dr. Scott's testimony about mental health. Dr. Scott admitted that she's not an expert in mental health. She draws her testimony based on her experience being married to a psychiatrist and the fact that she's an OBGYN, but she holds no specialized training or direct academic or research experience on questions of mental health. In contrast, plaintiff's rebuttal witness, Dr. Antonio Biggs, whose declaration was admitted into evidence, has extensive experience and training specifically looking at questions of abortion and mental health. And based on her research and her deep familiarity with the literature in the field, Dr. Biggs explained in her declaration that there's no reliable evidence that abortion, including second trimester abortion, leads to any increases in mental health harms. She also explains that the research relied on by Dr. Scott is deeply methodologically flawed, including because it doesn't control for prior mental health history or relies on inappropriate comparator groups. By contrast, the highest quality data, including the Turnaway study with which Dr. Biggs was directly involved, has a strong methodological design, a prospective design, and a unique comparison group that looks specifically at the question of mental health outcomes between women who wanted abortions but were denied them and those who were able to get a desired abortion. And that study found no evidence that having an abortion had resulted in any increase in mental health harm. And to the contrary, actually found that being denied a wanted abortion can have short-term mental health consequences and long-term adverse consequences for women's lives, including their socioeconomic security, their aspirations for their future, and their overall well-being. So again, on this question, the state's evidence simply cannot carry the weight under strict scrutiny to show that HB5 will actually advance, let alone that it's necessary to advance the state's interest in maternal health. I also want to just briefly address the least restrictive means prong. Here again, the state bears the burden of proof to show that HB5 is the least restrictive means of advancing any interest in maternal health. And specifically with respect to the argument that it will encourage early abortions, I think it goes without saying that there's many other ways that the state could have encouraged early abortions without completely cutting off access to care after 15 weeks. The state has resources at its disposal through which it could have disseminated information about access to early abortion to make it easier for Floridians to identify early abortion access services. They could remove barriers like the mandatory delay law that recently went into effect and requires women to make 2 trips to their providers and thereby delay their abortion appointments. Or it could ensure that insurance and Medicaid coverage is available for women to make sure that they can afford abortions as early as possible. But the state did none of these things. It just simply cut off essential health care at 15 weeks. And again, that can't pass muster under strict scrutiny. Also on the least restrictive means prong, I briefly wanted to address the question of specific incidents in which complications are identified. Again, I think the notion that incidents like those that were in the record related to Pensacola, incidents where a specific provider is known to be out of compliance with the existing regulations and where the state regulatory and disciplinary authorities are already taking steps to address it, the notion that the least restrictive means of addressing situations like that is a statewide ban that applies across the board, including to high-quality providers, again, simply just cannot carry the state's burden under strict scrutiny. I'd like to turn next to the state's asserted interest in fetal life and fetal pain. So first, I just want to briefly say that as a matter of law, the state interest being asserted here is the same one that was addressed and rejected in Right TW as being not compelling until the point of viability. And Your Honor need look no further than the state's own brief to make that clear. The state refers to the interest as protecting, quote, children in utero. And the cases that it cites in support of this interest talk about state interests in preservation of life or protecting third parties that first of all have never been applied in the context of pregnancy or abortion in Florida court precedents, but also would be indistinguishable from the interest in fetal life if applied in that context. So put simply, none of the cases that the state has provided here provide any basis for this court to either distinguish this from what has already been addressed in Right TW, or to provide a basis for concluding that it is a separately compelling interest. But I think even more importantly, the evidence that the state put forward through Dr. Condick about this question also fails to satisfy the state's burden under strict scrutiny. Dr. Condick's opinions rest on fringe theories about fetal development that, as she admitted on cross-examination, are at odds with the conclusions of mainstream medical organizations, including the American College of Obstetricians and Gynecologists, the Royal College of Obstetricians and Gynecologists, and the Society for Maternal Fetal Medicine. Dr. Condick is not a medical doctor. She has no clinical experience providing care, maternal or fetal care. And in her own words, she is an animal biologist who does not work on humans. And yet, and more critically, her opinions are simply out of step with mainstream medical organizations that do specifically focus on this subject matter and have specialized expertise here. Dr. Condick agrees that the neural connections between the thalamus and the cortex do not exist before 24 to 26 weeks LMP. She just disagrees with every other leading medical organization that those connections are necessary for a conscious experience of pain. But she could not identify a single major medical organization that agrees with her about that. I think it's also important to note that even on its own terms, Dr. Condick's testimony on this question is a moving target. She describes conscious experience of pain, apprehension of pain, nociceptive pain, and provides a wide range of fetal ages at which she postulates that it might be possible that some version of an experience of pain could be possible. And in her prior testimony, though, she admitted that it's not possible to make a clear and unambiguous case that fetal pain does in fact exist, even at 18 weeks LMP, which of course is after the gestational age at issue in this case. So this sort of theorizing, these sort of moving targets about what might conceivably be possible, again, are simply insufficient to carry the state's heavy burden to prove that HB5 is necessary to advance a compelling interest, even assuming this interest could be compelling under In Re TW. And I'd also like to point out that Dr. Tien's testimony on this question should be given great weight. Dr. Tien is a maternal fetal medicine specialist. She has direct experience providing care in contexts that involve intrauterine surgery. And she testified that contrary to Dr. Condick's assumption, the use of anesthesia and analgesia in such surgeries are not indicative of any concern for fetal pain and rather serve independent purposes, such as immobilizing the uterus, relaxing the uterus, or immobilizing the fetus in order to ensure controlled conditions for those surgeries. But critically, where fetal procedures are performed that do not involve incisions into the uterus, anesthesia and analgesia are not used. If Dr. Condick's speculation about pain had any resemblance to established medical practice, then anesthesia would be used in this context, and they're not. And so I think Dr. Tien's testimony underlines how disconnected from modern science and medical practice Dr. Condick's opinions are. I'd also like to briefly address the least restrictive means prong with respect to the asserted interest in fetal pain. Again, I think the state bears the burden to show that this is the least restrictive means. The state says that its interest is just in preventing pain, and yet the means that it has chosen is to completely ban abortions. This is not a targeted regulation that seeks to just reduce or mitigate pain during an abortion procedure. It sweeps much more broadly than that to try to cut off access to abortion altogether and take the decision out of women's hands in general. I'll also note that, as some of your honors questioning on Monday alluded to, that if Dr. Condick's theories were correct, that would mean that HB5 is also under-inclusive. Dr. Condick testified about the possibility of fetal pain much earlier than 15 weeks. And so the fact that the state seems to disagree with its own expert about the precise point at which an interest in fetal pain or the existence of fetal pain is possible is yet another reason why the court should give this testimony no weight. So I think for all of those reasons, it's clear that the evidence presented simply can't carry the state's heavy burden under strict scrutiny to show that these interests are compelling, that HB5 is necessary to advance them, or that HB5 is the least restrictive means of advancing either. I think I've already addressed the questions about facial relief so I'd like to move on to some of the non-merits arguments that were raised, particularly with respect to irreparable harm. So the state has challenged plaintiffs' ability to rely on the clear and obvious per se irreparable harm that will befall their patients if HB 5 goes into effect. But as the Florida Supreme Court explained in the Gainesville case, violations of constitutional rights are per se irreparable harm that do not have an adequate remedy at law. And I think particularly in the context of a motion for a temporary injunction, where the sole purpose is to preserve the status quo and prevent irreparable harm, it would simply make no sense for there to be a rule that would require this court to turn a blind eye to obvious irreparable harm that will result from the enforcement of this law. And the state has identified no binding authority that says this court must do that. None of the cases that the state cites to support the argument that plaintiffs cannot rely on irreparable harm to their patients to satisfy the TI factors, none of those cases involve circumstances in which the plaintiffs are found to be able to assert the rights of third parties under third-party standing. And certainly, that was the precise situation in the Gainesville, Florida Supreme Court case. And in that case, the plaintiffs were similarly situated and were also asserting rights on behalf of their patients. And the court found irreparable harm specifically because of the infringements of privacy rights on women seeking to terminate their pregnancies in Florida without any sort of inquiry into separate irreparable harm for the plaintiffs. But in any event, plaintiffs have also shown irreparable harm to themselves. There's no dispute that plaintiffs currently offer abortions after 15 weeks and that they would be forced to stop that under coercion of the threatened criminal and licensing penalties that HB 5 carries. HB 5 will thus force plaintiffs to stop providing safe, comprehensive, and compassionate health care to their patients against their medical judgment and against the needs and best interests of their patients. That coercion and the damage to the relationship with their patients that Dr. Tien testified to both on the stand and in her declaration, those harms cannot be remedied by money or any other existing legal process, which is the definition of irreparable harm. And with respect to the state's argument that there can't be irreparable harm from damage to the doctor-patient relationship because it's the state's prerogative to regulate medical standards of care, if Your Honor reaches the irreparable harm factor, it will be because there's already been a showing of likelihood of success on the merits and therefore a likelihood that the care being provided after 15 weeks is constitutionally protected. The state cannot assert that it has a legitimate interest in cutting off the ability of doctors to advise their patients as to access to constitutionally protected medical care if Your Honor has already concluded that indeed the care that would be cut off by HB 5 is likely to be constitutionally protected. I'll turn now to third-party standing. The state is asking this court to be the very first one in Florida to hold that doctors lack third-party standing in circumstances like this to represent the interests of their patients. And it's asking this court to do so in the context of a temporary injunction application that, again, is seeking to preserve the status quo and prevent irreparable harm to those patients. Doing so would be contrary to the Florida Supreme Court's decisions in State versus Presidential Women's Center, in North Florida Women's Health and Counseling Services, and in the Gainesville Women Care case. It would also ignore the First District Court of Appeals' rejection of this precise argument in North Florida, which then, when it went up to the Florida Supreme Court, the Florida Supreme Court considered the merits without any concern about plaintiffs' standing. But in any event, plaintiffs, as we lay out in our brief, have satisfied all of the factors, the three-prong factors, for third-party standing. Defendants concede that plaintiffs have a close relationship with their patients. Plaintiffs also clearly have a concrete stake in this case, given that HB 5 targets them directly with criminal prosecution, license revocation, and other penalties. The Florida courts look to federal case law on third-party standing, as you know, and I would refer to Craig versus Boren, which talks about the parties that are actually subjected to the legal duties, obligations, and penalties are the most obvious claimants in situations like this. That's precisely the situation here. I would also point to the MedImmune U.S. Supreme Court decision as well, which also recognized that where where a party has ceased providing conduct that would, in order to protect themselves from threatened criminal penalties, that coercion that is under threat of government action is itself a harm giving rise to standing. And so that is clearly the case here. With respect to the hindrance, I think it's also very clear that there are obvious obstacles to individual patients bringing challenges to HB5. The cases that the state cited to point out that there are instances in which individuals have brought challenges related to pregnancy are simply an opposite. None of those are time-based abortion restrictions. What the state is arguing is that there's no hindrance here to a woman 15 weeks pregnant learning that she cannot have an abortion and then having to bring an independent suit, all the while racing against the clock at the risk of being forced to carry her pregnancy to term against her will if she can't secure relief in time. And if these proceedings are any indication, that litigation could involve not just procuring a lawyer and filing suit, but procuring expert witnesses, maybe sitting for deposition, going through an evidentiary hearing, all the while day in and day out being forced to remain pregnant against her will. I think the clear injustice of such an outcome is why courts have repeatedly found that abortion providers like plaintiffs can bring suits like this one in order to vindicate the rights of their patients. And lastly, Your Honor, this wasn't raised in the colloquy with the opposing counsel, but I did want to briefly touch on the issue of the bond. Plaintiffs, again, have shown that we're likely to succeed on the claim that HB5 is unconstitutional and understand that we must post a bond if this court is to order an injunction. The purpose of the bond is to protect against the possibility of damages should the injunction prove to be wrongfully entered. But defendants have offered no evidence in this case of what their reasonable damages might be. So if this court enters a temporary injunction here, plaintiffs request that it impose a bond of only $5,000 or something similarly limited. Defendants' arguments that the bond should actually be $1 million is frankly unserious and wholly unfounded. The state claims that such a bond would be necessary to cover lost tax revenues from future taxpayers who they maintain would be born if HB5 is not enjoined and prevents abortions after 15 weeks in pregnancy. So first, I'd like to point out that this argument is completely contradictory with their argument on the merits that HB5 is not actually going to widely cut off access and everyone is just going to get their abortions before 15 weeks instead. But moreover, their theory of damages is pure speculation. It's not an actual estimation of damages. Plaintiffs submit that there would be no damages from a wrongfully entered injunction in this case. But what the state has put forward, a citation to one article from self.com and sort of speculation that, that any future child born because someone is not able to get an abortion is going to live in Florida its whole life, pay taxes in Florida its whole life, and never draw down any tax resources from the state is again purely speculative. We cite cases in our brief showing that bonds based on such inadequate evidence and speculation are erroneous. Lastly, I just want to note that a bond amount of this size would be a huge barrier to future litigants seeking to vindicate constitutional rights. And so for that reason alone, in order to ensure that the courthouse doors remain open for vindication of fundamental rights, plaintiffs request a bond of only $5,000 or something similarly limited. Unless Your Honor has other questions for me, I think I would just reiterate plaintiffs' request.
Can you give me 5 minutes? I left one of my notebooks at the office, and I'd like you to briefly go through the injunction elements, the 4 injunction elements, and give me your thoughts on that.
Sure, absolutely.
Just a second. I'll be right back. If anyone needs longer, I won't start without you. Found the book. Okay, if I could hear your take on the four elements. I think was argued in your reply that if unconstitutionality is shown, the four elements don't need to be satisfied.
So in the Florida Supreme Court's decision in Gainesville, the court made quite clear that it's not that they don't need to be shown, but that the other elements in the context of a constitutional challenge pretty much flow directly from them. So where there's a likelihood of success has been shown that a law is likely unconstitutional, the constitutional violations are per se irreparable harms, and it is always in the public interest to prevent the enforcement of unconstitutional laws. On that last piece, I would also just briefly address an argument from the state's reply brief that it's in the public interest because HB 5 protects health and safety. I think, again, if the court has already concluded that HB 5 is likely unconstitutional, then that means that the state has not carried its burden to show that HB 5 actually advances any such interests. And so that would not weigh in favor of the public interest factor either. The public interest factor would weigh heavily in favor of preventing the violation of Floridians' fundamental constitutional rights.
Okay, thanks. I have nothing further. Thank you so much.
Thank you, Your Honor.
Let me ask the state to come up and just complete whatever you would like to argue. Just give you a little bit of scheduling. I'd like to go to about 11:30 or so, take an hour for lunch. If you're close to being finished, by that time I'll give you extra time to finish if you want to, or we'll
I have a
play
single page of notes, Your Honor, but I think you and we tend to get into back and forth.
Well, I've decided we've had enough Socratic dialogue today, so I'm just going to listen to you.
Okay, Your Honor. Where I want to start is with the standard for temporary injunction. That is extraordinary relief, and plaintiffs bear the burden to establish all four prerequisites. Now, I understand Your Honor's position that as to the likelihood of success on the merits prong, once they make a certain showing, the burden shifts. But that does not remove their burden to prove the other three elements. That is their burden. And there was a moment when counsel said that the state has not shown that HB 5 is in the public interest. That is not our burden. That is their burden. I want to talk about I have just a list of really quick points.
Sure.
So I'm just going to go through them. On third-party standing, one point I want to point out to Your Honor is that that's what we call a prudential standing theory. It's not jurisdictional. And what that means is that unlike typical standing, which is jurisdictional and cannot be waived, third-party standing is a waivable theory. So what that means is that if you have a case where the defendants do not raise the third-party standing doctrine, and the court presumes standing, that says nothing about whether standing was shown because it's this category of what we call prudential standing.
So if it's not jurisdictional, it's in essence an affirmative defense, which you can waive?
I don't think it's an affirmative defense in the sense that the state has the burden, but I think it's a waivable argument.
Yeah, you're right. You don't get to an affirmative defense at the party who has the burden.
But if the state never points out, hey, they didn't meet the elements, the court has no obligation to sua sponte address that issue. And therefore, these long list of cases where standing was kind of assumed but never addressed, I just want to put those into the proper context, which is that they're not ignoring a standing issue that the court would have a sua sponte obligation to investigate. They're ignoring a prudential theory that the defendant can and did waive in the vast majority of those cases. Other quick point, just on the injury in fact requirement of third-party standing, they talk about this coercion idea, basically that if you're being coerced not to do something, that's enough for injury in fact. And I think that's right in some cases. I think the question you always have to ask is coercion as to what? In the run-of-the-mill case, the plaintiff is the party possessing the right, and they're being coerced not to exercise their own right. And as I said at the beginning, we agree that in many cases that is enough for injury in fact. But this is where, once again, another argument we're talking about is intersecting with the third-party standing doctrine. And the question is being coerced not to do something that you personally have no right to do under the Constitution, it's merely implicating the right of another, is that enough for injury in fact? And for all the reasons we've said, we don't think it is. On the facial versus as applied standard, Your Honor talked a little bit about all women in all circumstances, and that it would be true that sort of because all women couldn't get an abortion after 15 weeks, that would maybe be enough to show all women in all circumstances. And I just want to make clear the state's position is that you have to think of actual circumstances, not hypothetical circumstances. Because if the test were, if you look at Gainesville Woman Care, what we call it Gainesville Woman Care 3, that would be the first district's decision reversing summary judgment. When they talk about the facial challenge standard, they say, we're not talking about women in this situation, we're not talking about women in that situation, we're not talking about women in this third situation. Any woman could hypothetically find herself in that situation. And so if the test were, could this person ever find themselves in this situation where it would be unconstitutional in their situation, if that were enough to satisfy this facial challenge standard, then what the first district said wouldn't have made any sense. When they're talking about all women in all circumstances, they're talking about the actual circumstances that people find them in, not some hypothetical set of circumstances that haven't occurred. And so I think, while hypothetically this might prevent all women, other than those who meet exceptions, from getting an abortion after 15 weeks, you have to look at the actual applications of the law, and the application of the law that I think plaintiffs agree with, that at least some women will schedule their abortions earlier. I think that's the point we're really focused on.
So if the legislature had reduced it to you can get an abortion for just 1 week after LMP, you couldn't make a facial challenge on that?
So I think that would be a different case because I don't think the state could show that a significant portion of people would just schedule their abortions earlier. Is that the test that an insignificant number of people have had their rights? No, you're right. It's all women in all circumstances, but I don't think that anyone could schedule it before 1 week.
So if okay, I was trying to come up with an analogy.
I understand the point, Your Honor. I think there is a line drawing problem. It may be that this same argument would be available for earlier weeks restrictions, but I think that takes me to another really important point.
Okay, go ahead.
Which is that the plaintiffs say that this understanding of the facial challenge doctrine makes a mockery of fundamental rights. And I think part of the problem with plaintiffs' position is they are proceeding on the assumption that only facial relief is available and that as-applied challenges are sort of not an adequate way to vindicate fundamental rights. And I think it's just the opposite. The U.S. Supreme Court has called as-applied challenges the basic building blocks of constitutional adjudication. As-applied challenges are available for the rare circumstances where a law is sort of unconstitutional in every conceivable application. And so I think insofar as the rhetoric is saying this can't be right because we wouldn't be able to get this facial challenge or that facial challenge through, we have to keep in mind that as-applied challenges are the principal mechanism to vindicate constitutional rights. I want to talk a little bit about the experts and just respond to a few points that the plaintiff said. I think if you look at Dr. Scott's testimony in full, she said that she was not a mental health expert generally, but she did have expert experience specifically on the mental health effects on people post-abortion.
Anecdotal data from her practice.
From her practice.
And she doesn't recommend people for abortions. She doesn't provide abortions. So we don't know how many people she would have. Would that be what a normal OBGYN would have, or is it more or less because she doesn't recommend for abortions, she doesn't provide? And that's perfectly her right to make that call too. I'm not criticizing her for it. But what's the quality of anecdotal evidence in trying to draw a conclusion?
The way I understood the totality of her testimony, including her report, her deposition, and her testimony, was that in her, whatever it was, 20 to 30 years of experience, she treats people who've had abortions routinely.
She said she has treated people who have abortions, and she may have said routinely. I just don't specifically recall that. But her evidence is primarily anecdotal, and I've got to be honest with you, under the new evidence standard for experts, I can never remember the name of it. Dalbert. She might even have trouble passing the Dalbert test if she's not trained in the area and doesn't practice in the area.
You're talking about mental health?
Opinions on mental health. that's not been raised. I'm not going to consider Daubert here. But it may go more to weight than admissibility, in that certainly I'm sure she has patients who have had abortions. It seems equally likely that if she's not referring people for abortions, that whatever doctor did refer that patient would be the one that would see them afterwards, maybe not always. But again, I'm making a conclusion or a speculation that's based really on no evidence, just like she's making a conclusion in some respect to this without the benefit of a study, a long-term study. Like, I keep wanting to call it Turnabout because there's a place in town called Turnabout. The study that Dr. Biggs was involved in and other studies. So I think the bottom line that comes to a weighing situation. I take into account that she's not an expert in mental health by her own terms, but I know that all general practitioners deal with these issues to a certain extent. And under the non-Daubert standard, she probably would be allowed to testify because she has training, and the old standard is training and experience. Training or experience allows you to testify as an expert. Maybe she'd qualify under Daubert, but in the old days, pre-Daubert, it would have merely gone to the weight of her testimony, not the admissibility of it, particularly in a non-jury context. Sorry.
I understand.
I went off on a tangent.
No, I won't debate that with you. The only thing I would say is that I think she provided more of a groundwork for this in her deposition. We didn't spend a lot of time pushing back on what they elicited on cross-examination because we felt like we already had it in the deposition transcript. But
Dr. Condick or Dr.
Dr. Scott is the one.
Dr. Scott is the deposition already.
Yes. Regarding Dr. Condick, I did want to push back on the idea that she's just she's just an animal biologist, I think was the way it was framed. And just be clear, maybe
it was animal neurobiologist.
Well, she studies mammals, which human beings are.
Right.
And her current faculty position is teaching at a school of medicine to medical students who are being trained. So she's not a physician. But the idea that she doesn't have expertise in humans who are mammals and part of her training, I think, is not correct. And that's evidenced by where she teaches.
I don't think it goes to admissibility. Like most experts, their background, their opinions, all the other issues generally go to weight as opposed to admissibility.
Understood, Your Honor. I want to make 2 points about fetal pain quickly. One of them is that on cross-examination, Dr. Tien admitted that one of the sources cited in the study she was relying on said there is at a minimum uncertainty about when fetal pain begins. And the state's position would be if there is even uncertainty. Now, we don't think there's uncertainty. We stand by our expert. But even if all there is uncertainty, if there is a chance that we are inflicting pain on a conscious living being, we would think that the state has a compelling interest in erring on the side of caution with something like that. I want to reframe the issue a little bit. I think I did this already, but the way I heard plaintiff's counsel describe it, she suggested that that Dr. Condick actually think pain begins much earlier than the 15-week line. And I want to go back. I know I already said this, but
I understand. What she said, add 2 weeks to that range.
Well, first of all, she talked about 2 different types of pain, like pain reaction and conscious pain.
I didn't. I'm not so sure. I'm still really pain versus self-awareness of pain.
That's correct. So think about this.
So pain's a reflexive action. Reflexive action. If you're touched, you pull back. Is that
exactly? So like if you were to go into, as I understand it, if you were to go into the uterus and I don't know, inflict something on the child in utero, the time at which the child might simply recoil, that would be earlier than what we're talking about. But what we're talking about is not just sort of the sort of local nervous system between the spinal cord and, say, the hand that says, I'm touching a hot stove. The second stage is the thalamus, and then, as they pointed out, the third stage is the cortex. So what Dr. Kondik is saying is that you have sufficient sort of thalamus development at 14 weeks LNP, and what the plaintiffs are saying is, no, you need cortex development at 24 weeks LNP, and that seems to be the whole dispute. But the idea that the state is somehow far away from our experts is just not correct. We're talking about conscious awareness of pain, which she said begins at a range as early as 14 weeks, which is within a week of what the legislature selected.
You don't see any inconsistency in the state's position that this bill, in part at least, the compelling state interest is to avoid pain, and they said it during a time period when their own expert says there's pain?
In that it's whether being sort of off by a week on the range is enough to defeat narrow tailoring, I think we would disagree with that, especially when you couple it with the way the abortion procedure changes at 15 weeks and that kind of relevant cutoff. We think it's a belt and suspenders approach, and we think overall it's a defensible
If you
cutoff.
think there's pain, though, at week 14, and you take a pill that, in effect, induces a miscarriage, is your expert saying that is no pain, it doesn't have a reaction, a reflex reaction?
Well, I don't think medication abortion is available at 14 weeks, but I take the general point. I think what our expert, if you're saying sort of an abortion procedure at 14 weeks, I think our expert provided a range. We think the lower end of that range is very close to what the legislature selected. I agree with you, it's not at the beginning of the range, but it's close. We do think the legislature has some discretion to select time within the range. Let's see, I just want to make sure I've covered everything here. The last thing, I have one point I want to make in closing before I do that. I want to talk about the scope of relief. We raised an argument about this.
About statewide versus not statewide?
Yeah, the plaintiffs offered a little bit of a response in their reply, but plaintiffs' counsel didn't even address it here.
Yeah, they did discuss it in their reply.
Yeah, they discussed it in the reply. I mean, our view is the temporary injunction specifically is about maintaining the status quo between the parties. Therefore, injunctive relief should only run to the parties. We actually think there's also case law that says that injunctive relief is only supposed to remedy the irreparable harm in the case. And so we think there's even an argument that because only Dr. Tien presented evidence, that injunctive relief should be limited to Dr. Tien. Now, I understand some of this depends on what the court finds the irreparable harm is. But whatever the court finds the irreparable harm is, assuming the court grants an injunction, the relief should only prevent that irreparable harm. Didn't the Chief Judge Francis, there were 3 judges, maybe 4 circuit judges in the Gainesville case, but Chief Judge Francis was the judge who issued the temporary injunction. Wasn't that a statewide injunction? I believe it was. I would say a couple things. One, the state didn't make an argument about this, so I think they waived the argument. And second, I think Byrd has provided a lot of clarity about the nature of the writ of injunction. Now, is Byrd still... I'm asking, I don't have an opinion on this. Byrd is the congressional district case. Correct, okay. That's an opinion based on a motion. Let me see if I can get this straight. The Byrd 1, the first opinion. Byrd 1 is setting aside the stay of the stay. I know that's poor English, but there's an automatic stay on appeal. The trial judge voided that stay in Byrd 1, reversed the judge on that point. Yes. And then made some other comments about injunctions and status quo. I'm not denying it made other injunctions, but that was the essence of that. Was Byrd 2 a further discussion of Byrd 1, or was it intended to be the opinion of the court on appeal? Because if it was done before the appeal was briefed. So I'm assuming Byrd 2 is a fuller explanation. Byrd 1 came out within a day or so. As I understand it, the opinion was just an explanation. All right. So I'm going to look at my co-counsel and see if they're not
So here's my question, because I've seen this several other times. Tell me if you know, is the panel that decides motions the same as the panel that the case is assigned to for ultimate decision at the First District?
The answer is I don't know, Your Honor. And if your next question is it binding, I also don't know the answer to that.
That was my next question.
But I guess what we would say is we also find it persuasive. We think it's an accurate description of the constitutional writ of injunction.
I agree at a minimum it's persuasive. And I just don't know the binding status of a decision on a motion. I just don't know. It's binding in that case.
Yes.
Whether it's binding beyond that case, I don't know.
Well, I can tell you at in federal court, this is somewhat disputed, whether a state opinion is binding on the 11th Circuit, for example. I think it actually varies by circuit. It's a hotly contested issue, and it would not surprise me if the First Circuit has not said one way or the other.
I think the 11th Circuit on the federal level, they use different panels they have motion panels, and then they have case panels, and that's why I was asking, do you know? Has no effect on this case at all. Just, do you know whether the First District uses different panels? I don't know that. I don't think it's proper while I have any cases pending there for me to go ask one of them, which I haven't done.
I think we probably have cases pending there too, Judge.
Yeah.
I don't know.
Okay. Anything else?
Yeah, one last point, Your Honor. I feel like I would be remiss if I did not address the discussion of non-fatal abnormalities. I think it is true that the way screening techniques work, there will be non-fatal abnormalities that are diagnosed after 15 weeks. These would not fall within the fatal abnormalities exception. We, of course, believe that that's something to be addressed via as-applied challenges, not via facial challenges. But I also just want to note for the record that the state disagrees with plaintiffs on whether it is essential that plaintiffs be able to single out children with these sorts of conditions for abortion. These would include things like heart defects, spina bifida, cleft lips, clubbed feet, and Down syndrome. And the state feels very strongly about that. Thank you, Your Honor.
All right, thank you. Does the plaintiff have any reply?
Thank you, Your Honor.
Mm-hmm.
I'll be very brief. I just want to address a couple of specific points that were raised. With respect to third-party standing, the state argued that none of the Supreme Court cases or none of the cases that we had cited had actually squarely addressed that case. I did just want to point out that the First District Court of Appeals did specifically address standing in the North Florida decision that then went up to the Supreme Court and rejected the state's challenge in that case to third-party standing. So there is a First Circuit decision in which it was specifically addressed, and while that decision was reversed on the merits, the standing analysis, I think, holds true and is certainly something to take into consideration here. I know I didn't address statewide relief in my initial comments, and if I could just, it is in our reply, but I would just hit a couple of points here in response to that. If the court concludes that a temporary injunction is warranted here, it will be because there's been a conclusion that there is no set of circumstances in which the state can constitutionally apply HB 5 to deny access to abortions after 15 weeks. And yet what the state is essentially asking with its argument about statewide relief is to then sort of turn around and ask the court for permission to nonetheless continue to enforce a law that this court has found to be likely unconstitutional just because of the happenstance of where patients happen to seek their constitutionally protected care in the state of Florida. That's not what the Florida Supreme Court did in Gainesville, where a statewide injunction was explicitly affirmed as the proper scope of relief, and it wouldn't make any sense to do so here either. We cited in our case to Planned Parenthood of Greater Orlando, in our reply brief rather, to Planned Parenthood of Greater Orlando, which emphasizes that a temporary injunction is an equitable remedy, and that a court of equity should not be shackled by rigid rules of procedures that preclude justice being administered according to good conscience. And we would emphasize that the notion that a law could be determined to be likely unconstitutional in all circumstances, and yet the state would be permitted to continue to enforce it and continue to cause irreparable harm to Floridians is not consistent with justice and good conscience. And just on a practical matter, I would note that it would be an incredibly inefficient system. What the state would then be asking is for every single provider, or indeed every patient, seeking abortion after 15 weeks in the state of Florida to bring an identical challenge with identical claims as the ones that have been brought here. Lastly, just two other points. With respect to fetal pain, there was some discussion about the state arguing that it has a compelling interest if there is at minimum uncertainty on that question. I would note that this is not a situation in which the legislature made any findings of fact suggesting that fetal pain is in fact the purpose behind this law. There were no findings of fact in conjunction with the passage of HB 5. So while the Florida Supreme Court has noted that there are certain circumstances in which deference to legislative findings of fact might be appropriate, and that even in those circumstances, the court nonetheless still has an obligation for independent judicial review, there are no legislative findings of fact in this case for the court to defer to, including with respect to the question of fetal pain. And on the very last point that the state raised about fetal abnormality, this is a newly asserted interest that they have not previously raised in any of their briefing, and so I would just note that that's not an interest that had been raised or that plaintiffs had an opportunity to reply to prior to today. So just wanted to make those few points, and other than that, we would rest on our briefs.
Okay, thank you. Before we go, I want to break. Is an hour enough for lunch?
Yes, sir. Hey, can I just give you an answer to the bird question we looked when we were sitting here?
Bird 1 and 2?
Yeah, I guess
okay.
What they did is they vacated the temporary injunction for the reasons stated in their previous order.
Right.
Remanded.
That would be a ruling on the merits of the injunction.
Correct, Ron.
Okay, thank you. Unless you all want more than an hour's enough for me. It allows me to get lunch and also think about your arguments. So we'll come back at 12:30, and then I'll be ready to give you a ruling. It'll be verbal. I would say that it might not be completely flow like an order would flow for reasons which I think you know about my schedule this week and the need to get an opinion as soon as possible. My order is only going to be binding on the day I sign the written order. I just don't think in a case like this I should order something without giving all the reasons why I order it at the time I order it. That's why I'm going to do I want to do a written order. And I will be specific on some points. Other points I will incorporate certain arguments by reference. And I may give you more findings of fact than the parties think need to be put in, but I'm going to suggest some findings of fact to be put in also. I did note in the Gainesville one, I think the one that reversed Judge Francis, there was some criticism in that case about not having sufficient findings of fact, so that attuned me in this case to the extent possible have findings of fact to assist any review in court. Frankly, I did not have the time to go through all the different findings of fact I'm going to give you and tell you whether one I just gave you 10 minutes ago is the same as I just gave you now, so there will be some overlap. What I'm going to try to do is go by several documents and identify those in general. The other thing I would suggest on the order is when we're advocating, I understand language that advocates use. I would like to delete advocate type language in the order, and I thought the presentations by both sides were very good, but I don't want to take as the president says, take the hyperbole out, so I will make it as short as I can, but I'm not necessarily known. I know the Tallahassee Council may already know this for the brevity of my ordering, but I'll try to make it as brief as possible. And I have given it a lot of thought, and I have made, to the extent the time allowed me to, made some notes, and I'll read those. I'll go through those notes with you, and we'll go from there. If I miss something or if I misstate something, I don't mind you saying, hey, you need to address this, or no, that didn't happen. Because there was a lot of detailed evidence on Monday. The arguments are not arguments that I've seen them several times, but most judges don't see these arguments on a regular basis. For example, the strict scrutiny argument is something that's not unique to this case, but it's an argument that a lot of judges don't see every day. And in Tallahassee, we get, I think, the benefit of seeing those types of arguments and standing arguments and other arguments more so than other parts of the state. So I'll be ready at 12:30-ish, and you all have a good lunch. And I want to say this to all the lawyers. This hearing, both Monday and today, is a model of how lawyers advocate for their clients. Both sides advocated strongly the client's positions, but you did it with professionalism and often humor where appropriate. And you didn't call each other names. It was something that I would hope some law professor somewhere might want to show a trial practice class on how to behave the way advocates are supposed to behave. You're supposed to represent your client and advocate for your client, but you're not supposed to engage in rude or unethical behavior or anything like that, which this was a model of how to do it right. So thank you very much, and I will see you all in an hour. Okay.